The Honorable Court of Tennessee is back in session. Please be seated.
Good afternoon and welcome to the afternoon session of the Court of Criminal Appeals. Once again, let me introduce the panel today. To my right is Judge Rob Montgomery from the Eastern Division, Kingsport, Tennessee. To my left is Judge Jill Ayers from Nashville, the Middle Division. My name is Camille McMullen and I'm from Memphis, the Western Division. Parties know, well, I think the parties know the process here today. 20 minutes per side. If the appellant wishes to reserve rebuttal time, please announce that at the top. We do operate by the light system, so be mindful of that. But if you let us know, we'll also try to keep you on track with time. Call the next case.
State of Tennessee versus William Swafford.
Good afternoon, Your Honors. May it please the Court. William Gill from the Public Defender's Appellate Division. I'm here today on behalf of Mr. William Swafford, who is the appellant in this matter. With the Court's permission, I will reserve 4 minutes for rebuttal. There are 2 issues before the Court in this matter. Today, during my argument, I will focus on the evidentiary issue, which is the second issue in our principal brief. I'm, of course, happy to answer questions about any issue that the panel would like to explore. But absent questions, I will focus on the evidentiary issue. This is a case in which credibility played a significant role as to the most important and severe offenses that were charged. Those include especially aggravated kidnapping as well as rape. And during the trial, in this case, the state was permitted to bring in a substantial amount of inadmissible testimony and use that testimony to launch an improper attack on the credibility of Mr. Swafford. Because that was highly prejudicial to Mr. Swafford, this Court should reverse the case so that a new trial may be held. The most important aspect of this evidentiary issue is that the state introduced the testimony delivered at the preliminary hearing by Mr. Swafford's late wife, Jessie Swafford, for one sole purpose, and that purpose was to attack his credibility. We know that because at the trial level, the state told us that, indicating that the sole purpose of that evidence was to show that Mr. Swafford was untruthful, and to show that he was untruthful specifically in his statement to the police, which was recorded and which was introduced by the state as evidence during his case in chief. The state attempted to bring this in as impeachment evidence using 2 methods, but neither comported with Tennessee evidentiary law. The first was a prior inconsistent statement. So as I mentioned, the state brought in Mr. Swafford's recorded statement to the police in which he offered an account in which he admitted to some things, but largely provided an account of the events that would not have supported criminal liability, especially on the most severe charges. And then after that, the state brought in a different account of events, and that was the account delivered during the testimony at the preliminary hearing in this case by Ms. Swafford. And what the state contended was that that statement by Ms. Swafford should be attributed to Mr. Swafford. They expressly said that to the jury. They said, this is a story that Mr. Swafford came up with and adopted as true, and it shows that he was not credible. But the problem with that is simple. Tennessee law does not allow a prior inconsistent statement by anyone other than the witness or the party who is being impeached. So if a witness is going to be impeached by a prior inconsistent statement, it must be a statement by that witness. This was not a statement by Mr. Swafford, clearly.
So at trial, I mean, did the state say that to the jury before they put on the tape of her prior testimony?
The state argued, when there was an argument about the admissibility of this evidence,
right.
The state contended that the defense Mr. Swafford adopted the statement as true when he called Ms. Swafford, his late wife, at the preliminary hearing. She was a defense witness. And then during closing argument, that was when the state communicated to the jury that this was a statement by Mr. Swafford.
Did the judge provide any instructions about how the jury was to consider it? Other than just a witness that was an absent witness, but because it was under oath and she's not available, then the jury should consider it for a sworn witness's testimony?
The trial court's instruction was very much along those lines, Judge Montgomery. Before they played the recording, which took about 15 minutes and spans several pages in the transcript, the trial judge said, this witness is unavailable to testify. I believe the trial judge may have indicated that she had passed away, which was the case. And the trial judge instructed the jury that they should consider this evidence just as though she were here testifying.
Okay, so either party, when they put on a witness, and I assume the state, by playing this tape, was putting her on as a witness for the state, correct?
I believe it's appropriate to
And it was
characterize
during their
Yes.
case in chief, was it not?
I'm sorry?
Did they present it during their case in chief?
Yes, Your Honor, correct.
So they're putting on witnesses to prove the elements of the offense.
Correct.
And so when an attorney is submitting a witness to the court, whether it's a live witness or somebody, are they not themselves saying that it's truthful?
No, Your Honor.
Well, but I thought lawyers had an obligation when they present a witness. They're not supposed to put on a witness that they believe is going to lie.
There are rules of professional responsibility
Right.
that pertain
And
to.
So when the state puts on a witness that they believe is not telling the truth, are they putting on a witness that they believe is telling a lie and therefore violating the rules of professional responsibility?
We have not raised that
No,
possibility.
I'm just asking in general. Do you think that that's the case? I mean,
Well-
I've never dealt with this kind of a situation, but from what you're saying, it sounds like the state believed that what she was telling was not true, that she was lying. And if she's lying, is the state putting her on their case in chief and not and enabling her to tell a lie?
I'll address first, what I think is the appropriate way to think about the ethical ramifications and then move to the evidentiary part. I believe that from an ethical standpoint, it would be problematic to suborn perjury, to allow a witness to go up and say something that you know is not true and then to represent it as true. Now, the state did not do that here. The state played testimony that they believed was not true, and then they told the jury that it was not true. And so at no point were they indicating that they thought this was true. However, there's a different legal perspective when we look to Rule 607, and that comes from the voucher rule. And so dating back to ancient Anglican law, it used to be the case that when a party put a witness on, that they were vouching for that witness's testimony, and they were legally adopting everything that witness said as true. And the state quoted that and relied upon that principle at the trial level. There's one problem, though. That rule was abolished and has no place in contemporary evidence law. That rule was abolished from the federal rules of evidence in the 70s and Tennessee soon thereafter. If you look at the State v. Jones case cited in our brief, it's very clear that any party may impeach any witness and does not necessarily adopt the truth of a statement just because they call a witness. Moreover, Tennessee law pertaining to impeachment evidence is equally clear that Tennessee does not recognize prior inconsistent statements through this adoption method. It must be a statement by the witness. There are some other jurisdictions that allow that type of adoption theory, but even in those jurisdictions, this would not pass muster because it has to be a very express adoption, such as a person who takes a written statement and endorses it or affirms, I adopt this statement as true. Under no jurisdiction that we have found and that is cited in the briefs is there any case or any rule of evidence that says a party adopts a statement as true just because they call the witness at the preliminary hearing, such that it can then be used as a prior inconsistent statement against that party. Now, if Mr. Swafford himself had testified at the preliminary hearing and had said these things, of course it's fair game. But where the state went wrong here is using a statement by someone else and attempting to use that and attribute it to the defendant, which they did very expressly in their closing argument.
I'd like for you to spend a little time addressing the state's argument on waiver on these issues.
Certainly, Your Honor. So I'll address just how it was argued before trial and then speak to the motion for a new trial after that. This matter was litigated in a hearing before trial. So the state filed a motion, and it wasn't styled as a motion in limine, but it was in the nature of a motion in limine, seeking to introduce this evidence as admissible hearsay under the rule for former testimony by an unavailable declarant. So there was a hearing on that. During that hearing, the defense counsel specifically said, this is improper impeachment evidence. And the defense counsel articulated that it was improper, number one, because it was a prior inconsistent statement by somebody else, the matter that I just discussed. And number two, because the state should not be permitted to offer contradiction evidence based upon an account that they do not offer as true. And that's the other method of impeachment that is addressed in the brief. And so our position is that the matter was very thoroughly raised by defense counsel at the pretrial hearing, and then the trial court chose to apply the wrong legal standard by focusing only on hearsay and Rule 403, to be fair, but did not address the impeachment arguments. But the impeachment arguments were made.
But there was no objection or preservation in the record on the hearsay issue at the trial court, was
On the
there?
hearsay issue,
Which is raised in your brief.
I did explain in my brief why this was just simply not hearsay, and no one noticed that at the trial level. I would submit that should have been apparent, that when something is being offered for its falsity, that is not for the truth of the matter asserted. But what that really just goes to illustrate is that, let me put it this way, Your Honor. The trial court had before it two positions. One position was from the state, which was arguing this should be adjudicated as hearsay. Hearsay should apply. And then you had defense counsel who said this should be adjudicated as an impeachment matter. This should be adjudicated based upon the rules governing impeachment and 403. And the trial court chose to go primarily with the hearsay. And so we contend that was the defense counsel's specific opposition and his articulation of the same rationales that we are advancing, with the exception of the lack of the truth of the matter asserted, which I thought was just nice to provide a complete analysis, that is sufficient to preserve the issue. Turning to the motion for a new trial, which is the other place where the state asserts waiver, in the motion for a new trial, in the written motion, defense counsel had a section entitled, it was either miscellany or miscellaneous, one of those two terms. And in that, he expressed that the state, first of all, he complained again about the admission of this testimony, this same testimony. And
On what grounds, though?
on the part of the grounds, and there were a few things expressed, he did mention Rule 403 specifically, but he also said that it was an improper attribution of someone else's statement to him that resulted in undue prejudice. And so our contention is that is the heart of the impeachment issue here. The court may look at that and say it could have been more artfully preserved. Nevertheless, we believe that the matter was put before the court sufficiently to preserve it. That is, I think that covers the contours of the waiver issue. Of course, the state does not have anything regarding the substance of the impeachment argument that I just went through. The state also does contend that it was harmless error, and so I might just briefly touch on that. This court, I believe the Tennessee Supreme Court's 2022 opinion in State versus Moon is highly instructive here. In that case, this court had found that there was harmless error, and the Tennessee Supreme Court reversed. And the reason it did so was because there was highly prejudicial evidence improperly admitted. And the reason the evidence was highly prejudicial was because it constituted an improper attack on the credibility of the defendant and or the defendant's witnesses. And so when you have offenses where credibility matters, and then you have improper evidence that bears directly upon credibility, Those are the ingredients for prejudicial error, and so this court should not hold that that error is harmless. My friend, of course, points to substantial physical and forensic evidence in this case. What I would say about that is, if you go through and look at that physical evidence, the extensive injuries suffered by Ms. Bennett in this case, which were not disputed, they pertain exclusively and mainly corroborate the aggravated assault, which was the least severe offense in this case. When we get to the more severe offenses, including the rape, including the especially aggravated kidnapping, they are much more credibility dependent. For example, with the rape, we had substantial DNA evidence, all of which came back negative. That included vaginal swabbing, that included oral swabbing, that included DNA testing of a tampon that Ms. Bennett was using during the course of these events, all came back negative. That included DNA testing of certain articles of the defendant's clothing, which all came back negative. And the primary physical evidence that is pointed to in the state's brief is an injury. The state's witness referred to vaginal tearing. She did refer to it as very small tearing and specified that it could have been caused by consensual or non-consensual activity. And then when you look at the especially aggravated kidnapping, it is highly dependent. First of all, for the reasons explained in our brief, the evidence was insufficient as to that offense because of the incidental nature of the confinement. But in any event, it was highly dependent upon Ms. Bennett's testimony as far as when she willfully went into the Jeep and then that turned into a less consensual type of confinement. And so for those reasons, we contend that this evidentiary error does warrant a new trial.
Thank you, counsel. General Spangler.
Good afternoon. May it please the court, Nick Spangler for the state of Tennessee. If I could, I think I'll focus my time on the evidentiary issue unless the court has questions about the kidnapping part of the argument. So here the trial court was well within its broad discretion to admit Ms. Swafford's preliminary hearing testimony because it was certainly relevant and not unfairly prejudicial. And to be clear, the defendant has definitely waived any argument for exclusion under the hearsay or impeachment rules. The state filed a specific written motion to admit this evidence under 804B1 and to admit it for the truth of the matter asserted. That was in the motion. And not only did the defendant not object to that motion, but he tacitly agreed that 804B1's requirements are met, and the trial court noted that agreement in ruling that it was admissible under 804B1. So that issue is waived. The defendant argues, and I agree, that the prosecutor did make arguments that some of this testimony should be believed, some of it shouldn't be. To the extent he's arguing that the state therefore offered it not for the truth of the matter asserted, that would have been a great thing to bring to the trial court's attention and maybe parse through this entire preliminary hearing testimony and say maybe some of it's appropriate, maybe some of it's not. Certainly the state offered for the truth of the matter asserted the testimony that Ms. Bennett performed oral sex on the defendant because that established the essential element of sexual penetration. So at the very least, it was offered for its truth on that. But otherwise, any objection that it wasn't offered for the truth of the matter asserted is waived, and the defendant cannot show plain error. So I do want to touch on the impeachment part. The defendant did argue, he mentioned the word impeachment in the pretrial proceedings and said this is not appropriate impeachment evidence. This is just not impeachment evidence at all. This is my substantive response, is none of the impeachment rules apply here, and that was not the state's theory of admission. The state's theory of admission was a hearsay exception, 804B1. If you go through all the impeachment rules, and I did, none of them apply, but those are not rules of exclusion. Those are rules for if you want to introduce certain types of impeachment evidence, you have to meet those rules, but that was not the state's theory of admission. This was no more impeachment evidence by Ms. Swafford than Ms. Bennett's eyewitness testimony was impeachment evidence of the defendant's account of what happened that night. And they're not raising any arguments that Ms. Bennett's eyewitness account of what happened to her that night was somehow impeachment evidence. It's just a complete red herring and kind of a straw man argument. Nobody has ever asserted that this should have come in through the Rule 600 impeachment rules. It's just not applicable to this case. And in any event, even though he did, utter the words impeachment in his pretrial hearing argument, he did not preserve that issue in his motion for new trial. It was solely focused on 403 and relevance and undue prejudice. So those arguments are waived. I don't really want to get into plain error, even though they raised that in their argument. I think it can pretty much pair up with our argument as to harmlessness of this evidence. But I do want to touch on the 403 argument, since that's the only one that's preserved. So defendant did focus his motion for new trial exclusively on relevance and prejudice under Rule 403, but this prelim testimony was certainly relevant, and it carried absolutely no potential for the jury to decide this case on an improper basis. As I mentioned before, the testimony insofar as it established the essential element of sexual penetration was clearly relevant and probative, and to the extent that it did contradict the defendant's account that there was no sexual penetration, it was relevant to the issue of credibility. So certainly relevant, and no undue prejudice. I don't really understand the theory for undue prejudice here. They seem to say that because the prosecutor relied on this testimony during argument, that somehow exacerbated or augmented the prejudicial effect of the evidence. And we see this all the time in the court's analysis. If something's improperly admitted or is prejudicial, then yes, a prosecutor's emphasis on that can sort of bolster the prejudicial nature of it. But it doesn't create prejudice out of thin air just because the prosecutor made inferential arguments on that evidence at the closing argument. So we submit that there is no improper prejudice here, and if the court is inclined to disagree and consider plain error or harmlessness, this was harmless. I mean, Miss Bennett had the battle scars to prove what she went through. Her face was completely destroyed. She was covered in scratches. She had vaginal tears. They found DNA evidence on the defendant's shirt. Her phone and watch were scattered where she said they would be. Her clothes were scattered where she said they would be. There was all sorts of corroborative evidence in this case. So my point is not to say that credibility wasn't an issue at all in this case, but there was more than sufficient, abundant evidence to corroborate Miss Bennett's account of this non-consensual encounter with the defendant. I'm happy to answer any questions the court may have. Otherwise, we respectfully ask you to affirm the judgments. Thank you.
Thank you, Your Honors. Just to touch on a few points briefly. I'll just start with the fact of whether this is impeachment evidence and whether impeachment should govern. The Tennessee rules of evidence define impeachment evidence as an attack on credibility. You can see that in Rule 607. You can see it in interval decisions. If we look at the real purpose for why this evidence was admitted, and this is made clear in the state's own response at the trial level to the motion for a new trial, it was to attack the untruthfulness of Mr. Swafford, specifically the untruthfulness of his statement about these events. So when evidence is admitted, and when evidence is brought in for the sole purpose of attacking the truthfulness, that is the credibility of a statement, it is by definition impeachment evidence and should be governed by the rules that govern impeachment. And the fact remains that there is no way that this evidence can be categorized as valid impeachment evidence for all the reasons I discussed previously and set forth in the brief. Of course it should be discussed as impeachment evidence because its only purpose was to attack Mr. Swafford's credibility. The state tells us that at the trial level. Moreover, looking to the same principle of law that this court should look at the real purpose of the evidence, the court should not sanction an argument by the state on appeal in which it says that the state brought in Ms. Swafford's testimony about the element of penetration. Ms. Swafford testified to consensual sexual activity. I will not get into the details of everything that she talked about, but one thing is clear, she testified to consensual penetration. Everything that she testified to of a sexual nature was consensual. And so to say that that would prove an element of the offense of rape, had the jury believed what Ms. Swafford said, it would not support a guilty verdict for any rape offense because it was evidence of a completely consensual encounter, at least until a physical altercation took place later during her version of the events. And so looking at the real purpose of the state's evidence, it was to attack credibility. It should be categorized as impeachment. Defense counsel said that at the pretrial hearing. This is improper impeachment evidence. That's how it should be adjudicated on appeal. Speaking briefly as to the 403 issues, the state has failed to set forth any legitimate probative value as to this evidence. For the reasons I just discussed, they should not be able to put forth a pretextual notion that this was relevant to sexual penetration, when Ms. Swafford's testimony was to consensual sexual penetration and entirely contradicted the testimony of Ms. Bennett, who was the state's primary complaining witness in this case and who suffered the injuries. Once again, the physical evidence pointed to by the state pertains primarily to the aggravated assault. The only DNA evidence that came back positive from the defendant's shirt was blood stain, but Mr. Swafford maintained all along that there had been a physical altercation. His own version of events, frankly, was supportive of the notion that there was a physical altercation, which would relate only to the offense, primarily to the offense of aggravated assault. When we get to the other offenses, far more credibility-based. Finally, this evidence was highly prejudicial, and I do agree that when it comes to plain error, that's the main focus. And the reason it was so prejudicial was because it was an improper attack on Mr. Swafford's credibility. As a result, we ask that this court grant a new trial in this matter. Thank you.
Thank you, counsel. Well argued, well briefed. The matter will be taken under advisement. And Madam Clerk, are the parties for the next case present?
No, Your Honor.
Okay, can you call the third matter on the docket for today?
Be State of Tennessee versus Christopher Allen Kite.